I'm going to talk about constitutional law. So the goal here is to introduce a subject very quickly and then give you an idea of what it would be like to be in the class, what I would actually do in the class. So I'm going to go in depth on one particular topic with a case, just like we would in class, so you can see what it would be like. So I picked constitutional law as my course. That's my primary course at Dayton, though I've taught, honestly, almost everything in the program at this point. But constitutional law is where I do most of my writing, constitutional law around civil procedure, environmental law, et cetera, but usually something to do with constitutional law. And so that's my primary area of teaching at Dayton. And at Dayton, we divided into two separate courses. Now, in our program, it's one course, but it's a longer course. It's a 4-credit course. There are essentially two different parts of the course. There would be two different semesters in the JD program. For us, it's just a longer course. The first part of the course is on the structure of the government. And what I mean by that is the Constitution, of course, is the blueprint for the United States government. It establishes the 3 branches of the federal government and the checks and balances between those branches and the states. It basically sets up the government. And so we spend about half of the course talking about that. And you're going to get a much better understanding, I hope, of how the US government works and the constraints that it has on it. So we'll talk about judicial power. That, of course, is important for us as lawyers, the role of the Supreme Court, legislative and executive power. And primarily what we're looking at there are the limitations on those powers, because we'll see the federal government cannot do whatever it wants. It's very different than the federal government in Korea. The states, because of our federal system, the states are quasi-independent, quasi-sovereign. There are certain things that the states can do and the federal government cannot override them. So we'll spend a lot of time talking about that, as well as the checks and balances between the different branches. What happens if the president and Congress are fighting about a particular issue? So that's the first half of the course. The second half of the course is looking at individual rights. And there are 4 major topics here on individual rights, rights you have against the government. The first is due process. And what we mean by that really, and it's kind of odd, but we'll get into it, fundamental rights. Your key fundamental right there is your right to privacy. The government can't tell you what to do in your own home for, well, most things. We'll look at that. Your right to refuse medical treatment, the very controversial right to abortion, issues like that. Then equal protection, that's largely through the lens of race. That's why that is part of the Constitution, is the United States history of racial discrimination. But we'll talk about discrimination based on gender, sexual orientation, other classifications as well. And then freedom of speech, of course, is a huge one, the First Amendment. Freedom of speech, and then freedom of religion is a smaller topic, but it's also important separate topic that we would look at there. All right, so I decided for this course to do for this introduction, to do the deep dive into what is called the Free Exercise Clause. That is because I think it's a relatively straightforward topic where I can give you the basic idea in 10 minutes. I think that's all I need. And so the Free Exercise Clause is part of the First Amendment. The First Amendment, of course, includes freedom of speech. It includes freedom of religion. And it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So the Establishment Clause is something we would spend a fair amount of time in the course, and that has to do with government funding of religion, public displays of religion, etc. The Free Exercise Clause is looking at, can the government limit what you're doing in terms of worship or how you attend services? And where the cases usually come up is punishing people for their religious beliefs or treating them differently because of their religious beliefs. And at a sort of basic level, it's obvious that the government cannot treat someone differently. It cannot prohibit worship services. It can't, the government can't declare a certain religious belief, right? Those things are clear and obvious under the First Amendment. What all the cases are about are neutral laws, laws that don't mention religion, but that interfere with religious practices, usually unintentionally, or at least it's not obvious that it was intentional. So here's a silly example, but I think one that makes the point. There are some religions, ancient religions usually, I'm thinking like ancient Aztecs or something. There are some religions that at some point in history believed in human sacrifice, right? Well, of course, we have laws against murder. You can't kill someone else, that would be murder. And so a law against murder implicitly then interferes with a religious belief in human sacrifice. Well, obviously that law against murder is still constitutional. We don't care that it interferes with that religion. So when does that cross the line and become problematic, right? If you had the Congress passing a law saying no one is allowed to drink wine on Sundays, now all of a sudden Catholics, Christians are going to be very upset because they won't be able to engage in their religious practices. Would that be unconstitutional is what I'm trying to get at. And this issue comes up in different parts of the courses where we have laws that look neutral, but then they actually impact people in ways that they find limiting on their individual rights. So you could have a law, and this is big in the news and sort of the culture right now, you could have a law that looks neutral, but has disparate or different impacts based on race, right? And so would that be racial discrimination? You could have a law that neutrally sort of limits when and where people can speak, like a curfew or something like that. Does that violate the First Amendment? So this is an issue that is recurring throughout the course, and I thought we'd look at it with the exercise of religion. So early on in the Supreme Court's history, and I like to do this, I try to introduce the topic, give an idea of what is the issue, give a little bit of history, then give you the rule, do a case example, and then do some hypotheticals. All right, so early history, we have basically, if we want to be honest here, early history, the people in power in the United States were all Christians. And there wasn't much case law on this issue because there just weren't any disputes. Everyone basically had very similar religion who had power within the government. We had the Mormons, which then is really looked down upon by the majority religion. I don't know if you know anything about Mormons. It's a religion that originated in the United States. It's basically a branch off of Christianity. And we had laws that were targeted against the Mormons in the 1800s. The Supreme Court upheld those laws and said that because it was a neutral law, it was a law that outlawed polygamy, marrying more than one person, which was a tenet of the Mormon religion, but of course against the Christian religion, the traditional Christian religions. And so the Supreme Court upheld that, saying, well, if it's a neutral law, then the purpose is not to target religion and there's no problem. However, you fast forward quite a bit and we see the Supreme Court start to make exceptions in different cases, such as Sherbert, where we had, and this is similar to the case we're about to look at, where we had a Orthodox Jewish person who said that they didn't want to work on Sunday, I guess it was an Orthodox Christian who didn't want to work on Sundays, and that would violate her religious beliefs. And so the working on Sunday is the Sabbath. And so the court said, well, okay, the state cannot punish you for that, your unwillingness to work on Sunday, because it's your religious belief. Then we had an issue with the Amish as well. The court, basically what I'm trying to say here is the court was going back and forth and not giving a clear approach. And that is because, if you want to be a little bit honest about it, I think when you had a law that impacted a minority religion, like the Mormons or the Orthodox Jews in Braunfeld, the court is saying, well, the law is constitutional. But then once you had something that impacted the Christians or impacted, uncontroversially, the Amish, the court seems to be saying, well, now all of a sudden we have a problem. It's unconstitutional. So the court's kind of going back and forth, and that brings us to Schmitt. Schmitt is the modern case. This is our bedrock case that establishes the basic rule for the free exercise clause. In the course, we would look at a bunch of other cases after Schmitt that are applying this rule to different situations. But this is our basic case. If you understand Schmitt, you could get points on any essay having to do with free exercise. Excuse me. So again, our issue is whether a law that gives a neutral rule that does not mention religion can violate the free exercise clause if it impinges on or burdens religious beliefs. And in Schmitt, the court says the answer is yes. The government can do that as long as it is neutral and generally applicable. Excuse me, sorry. And so the court is saying here that as long as you have a law that is not targeted at religion, does not have the intent to burden a religion, then it is constitutional for the government to prohibit a religious belief. You know, it's okay to apply that law even if it limits religious exercise. All right, so I just said that rule in a very sort of general way, and you're probably thinking, well, what on earth does that mean? Well, that's where the cases and examples, I think, bring it to life. So Schmitt is the case. You know, of course, in the US, we have the common law method. We use cases extensively. It's really the vehicle for most of our legal education. So I do a lot of cases. So in the Schmitt case, Schmitt, there's a picture of Al Schmitt there. He's a Native American. He was a counselor at a, I don't know what's going on with my voice, I'm sorry. Counselor at a drug rehabilitation clinic. And he is fired from his job for ingesting peyote. Now, peyote is an illegal drug. It's something, you know, if you watch old movies or something like that, or, well, I guess modern movies, you know, it's something that, hippies or whatever, you know, people use. It's a psychedelic drug. It makes you hallucinate. But it's also a natural substance that Native Americans have been using in traditional religious practices for hundreds, if not thousands of years. So Schmitt is taking this peyote in the context of a religious ritual. There's no dispute on that. However, he's fired from his job and denied unemployment benefits because he was taking a drug that is illegal under federal law. It is an illegal drug. And so the issue then, he files a lawsuit saying, you cannot punish me for taking this drug because it is a part of my traditional, long-standing, honest religious beliefs. So can the government punish him for engaging in this religion? The court says, yes, Schmitt may be punished. Schmitt loses the case. And that is because, again, the court says, as long as the state law is neutral and generally applicable, that means it is not targeted at religion, the intent is not to burden religion, and it applies to everyone, not just religious worshipers, but everyone who takes the drug, well, then it's constitutional. And the court says this has to be the rule, because otherwise, people would get to pick and choose which laws they want to follow, right? I like to do the rationale to give you some sort of understanding as to why the court is doing what it's doing. I think it helps you to both remember the rule and apply the rule, explain it when you're applying the rule in an essay. So the court here is saying, if we had any other approach, it would be too difficult to litigate. And that is because anyone could say, well, my religious belief is that I get to do whatever I want. My religious belief is that I get to ingest peyote. I get to smoke marijuana. I get to park wherever I want. I get to be really loud in the middle of the night. You could try to get an exception to any law. That's where the court says we can't let people be a law unto themselves, get religious exceptions. Now, you might be thinking, well, the court could just say that's not a real religious belief. You don't really have a religious belief about using marijuana. You don't really have a religious belief about using cocaine or being, parking wherever you want or being really loud. Well, the court says they do not want to make value judgments about what is a good religion, a real religion, and a fake religion or something like that. The United States, of course, is a very big, populous, sort of diverse place. There are new religions popping up all the time. You know, sometimes we call them cults, but what's the difference between a cult and a new religion, right? I mean, the court doesn't want to have to make those decisions. And so your freedom of religion applies to essentially anything you claim is a religion. The court is not going to monitor that. And because the court is not going to pick and choose what is a real religious belief or which religious beliefs deserve protection, it says this rule is necessary. This rule is necessary. Now, of course, the criticism of this rule that you get from a four-justice dissent, and I want you to know this, it's important, I think, to understand how the rule works. That means that the legislature can burden religious practices as long as it's not doing so intentionally to hurt those people. That means people like Schmitt, the Native American, are probably more likely to face these types of burdens, right? Because the legislature may not really realize what's going to happen to those minority religions, those smaller religions, or it may not care. But that law I mentioned earlier, banning the ingestion, banning alcohol on Sundays, that's never going to happen because the legislature is probably never going to target Christianity since it's a majority religion. So that's sort of the critique of it. Okay, so then what I would normally do in the class, that's very quick. I would probably spend a little bit more time in the class, but not much. We would do other cases to explain the rule, to expand on it and apply it. But you just got the basic rule. As long as the law is neutral, as long as the law doesn't target a religion, it's constitutional, even if it burdens exercise. So then I would give you a hypothetical that is going to be bar style, similar to what you would see on the final exam, that is testing your application of that rule. And I know I'm going a little bit over on time here, but maybe it makes sense to just read this quickly, and then I want to talk about it. So let's just take a minute here to read this. And so what I would like to do in the class is try to get some discussion around this. Does anyone have a guess as to which answer is correct, A, B, C, or D? You can type it into the chat box. You can raise your hand. You can just unmute yourself and start talking. Anybody? All right, I'll just talk through it then. I'll keep bothering you in class about trying to get participation and discussion going, but the answer here is going to be B. No, because the law is neutral and of general applicability. Notice that it has those words I've been using. That's our rule statement built in. And just knowing the answer is not enough, right? Knowing that the answer is no, this law does not violate the Constitution, that's not enough. There are three answers that say no. You have to be able to identify the correct reason for that. And it's because of B, it's the rule from Schmitt. As long as the law is neutral, meaning it is not targeted at the religion, the government is not passing this just to hurt those people. It's a general law. It applies to everyone, general applicability. It's not just applying to this religious group. It's constitutional. A is, the setup here to explain it a little bit, right? We have a vaccination law. Everyone has to get vaccinated. Well, this is a real thing. I mean, this is not just a hypothetical. There are actually cases on this where then parents are saying, we don't want our children vaccinated. sometimes for religious beliefs. And the court has said, no, vaccination laws are constitutional. They're not targeted at the religious beliefs. And, you know, there's that public safety need. We would get into other issues that could come up with that in the course. But notice C is wrong. This does interfere with the religious beliefs. You might think, well, that's not a real religion, or that's a stupid religion, or whatever. But the court is not going to make those value judgments. It will take those religious claims at face value. The reason it's constitutional is because of that neutrality. It's not targeted at the religious group. And A is not relevant to the free exercise clause. That's wrong, because that's getting more at a privacy right rather than the free exercise clause, which is what I was asking about in the question. And so knowing the rule is going to help you be able to choose not just the right answer, but or not just, you know, yes or no, but also the right answer, the explanation for it. And the same thing would apply in an essay. If I had this as an essay question, I would expect you to be able to not just answer yes or no, but to be able to give me that rule statement, explain how it applies, and, you know, I would give you examples of that in the class as well. Okay, so I think my time is more than up. So I'll turn things over, but you know, I hope you enroll in the program. I'm excited to get started here relatively soon. And you know, if you have any questions, please feel free to reach out to me. I'll type into the comments box here my email, or you can just, you know, I'm sure you can find it in other ways. But I'm happy to answer any questions you might have about the program. And I hope you, I hope we see each other here in a few weeks, or a couple weeks actually.